state's case saw some witnesses who were inside the house testify, and their versions that two intruders entered the house. And what exactly were their roles? Accused number 3, Mthobisi Mncube, carrying a gun, and accused number 2, Bongani Ntanzi, followed him inside. Well, the state believes accused number 1, Muzi Sibiya, and accused number 4, Mthokoziseni Mapisa, were outside, while accused number 5, Fisokuhle Ntuli, was the man with the getaway car. This, a view even held by the lead investigator, Brigadier Bongani Kininda.
Now, what is your comment?
My Lord, it confirms what I've said earlier, that as I was trying to, right at the beginning, when I was trying to establish as to whether there were intruders or none at the preliminary stage of the analysis of this docket, this is one of the aspects that I looked at, and that is the first responding officers being informed that there was a shooting in progress, and the suspects, in his container statement, ran towards that direction, which is basically the park. So for me, the fact that the first responders, police officers, were informed clearly that the people who were involved in that shooting ran to a certain direction. It's a clear indication that there were people who were involved and they ran to a certain direction, and they were not found on that day, my Lord. And this, my Lord, as I've said, is in addition to the neighbors, the witnesses who witnessed people running out of that house after the shooting. So taking that information, which was disposed in the form of a statement, I couldn't ignore the fact that the only inclination or direction is that indeed there were intruders, because this is independent from the people who were inside the house, who were then questionable at that stage that perhaps were they telling the truth or not. These are independent people. These are police officers who were in duty, who simply responded to the crime scene, my Lord, and this is what they were informed. They documented what they were informed. They had no reason to mislead. And the neighbors and the people who also indicated that they saw people running to a certain direction, they were not part of the people who were inside the house. Those were simply eyewitnesses and neighbors who simply indicated what they observed, my Lord.
But exactly how were all the 5 men linked to the offence? The High Court in Pretoria heard that, amongst others, it was accused number 2, Bongani Ntanzi's confession that blew the lid and changed the course of police's investigations.
When I was walking away, my Lord, I just don't remember which of the 2 members called me to say he wants to speak to me. This is now accused 2. My Lord, when I returned, what he then said amounted to what led to the arrangement of the confession that was taken by Lieutenant Colonel Rapado. And he was cautioned, my Lord, in terms of his constitutional rights. I've dealt with this thing. I just don't want to bad in the record by repeating the same thing, my Lord. But I did caution him in terms of his constitutional rights when he made a confession, because in essence, he admitted that he was involved. He implicated accused number 1, 3, 4, and 5. Further mentioning my recollection, my Lord, Mrs. Kelly Kumalo as the trigger point or the person who hired them to kill the deceased.
Well, Kininda told the court that he had requested that Kumalo be charged, but a decision was taken that a further probe be conducted.
Now, in terms of your testimony, you mentioning that he is just a recouping, that Keg is a kingpin, not so?
Yes, the evidence, my Lord, that we collected suggests that she's a trigger point.
Cell phone records also linked Kumalo to accused number 5, Fisokuhle Ntuli, in August and October of 2014, prior to the killing. Well, the firearm that was also seized from accused number 3 had been linked to the bullet projectile recovered from the scene. Well, this was confirmed by multiple ballistics experts that took the stand.
I was then satisfied that the 2 bullets were then fired from the same firearm based on sufficient agreement of class as well as individual characteristics. After that, I placed a second test bullet on the right-hand side of the microscope. I repeated the same process until I was satisfied there was still sufficient agreement of individual and class characteristics. I then proceeded to inform Lieutenant Colonel Mangena that I'm of the opinion that the exhibit bullet and the test bullets were fired from the same firearm.
And while DNA results had excluded all the accused inside the house as well as on the hat, but the state believes that some traces of their DNA markers that were found were significant to place some of the accused there. Well, fast forward, after multiple delays, drama, postponements, the state finally wrapped up its case, believing it led strong and credible evidence.
That concludes the leading of the evidence for the state.
Okay.
And we close the state case. It's precisely 3 years since the state started leading evidence, and the state now formally closes its case.
While the defense will now have its turn, a possible bite at the witnesses that the state never called.
State had been indicating in the course of the leading of its evidence that it would not be calling certain witnesses. Those witnesses will be made available to the defense. Now, I want to, actually this is just a re-emphasis that from this point onward, in other words, henceforth, the defense is now in liberty to consult with whoever's name appears in the list of the state witnesses if circumstances were to arise. I just want to confirm if my understanding in that regard is correct, my lord.
As a court, my lord, the law is very clear that any witnesses who is not called by the state is at the disposal of the defense, and that will obtain here. We make all witnesses that haven't been called we make them available to the disposal of the defense, my lord.
When the case resumes next month, the defense indicated it will apply to have the charges dropped against the accused.
Got instructions from our clients that we need to bring an application in terms of section 174, which instructions we communicated to the financer of their defense, who is the Legal Aid South Africa. And Legal Aid South Africa then requested us to request an indulgence from the court to have the matter stood down for a week or two, whilst they would be busy working on their CMC. I don't know what that stands for, but I think it's a head committee there on the modalities regarding the financing of the application in terms of section 174, my lord.
But what are the prospects?
The defense is saying that they did not prove a case beyond a reasonable doubt, and the defense has indicated that they will be bringing an application for the discharge of their clients in terms of section 174 of the Criminal Procedure Act. Now, what section 174 clearly states is that it is a safeguard in order to prevent accused persons from being convicted if a case has not proven against them beyond a reasonable doubt, and that the only inference that can be drawn from them having to testify and from presenting a case is that they will in fact incriminate themselves even though a case has not been proven against them by the state. So I think we can expect that section 174 application by the defense when the matter resumes, and then it is up to the judge to decide whether to grant the section 174 or for the judge to say, well, I don't agree with this application. In fact, I do think that there is evidence on the record and that has been proven by the state that deserves to be answered to, and accordingly I call upon the defense to present their case. If the judge makes that ruling, then the defense case will entail the calling of witnesses, the possible calling of the accused, and other possible eyewitnesses, and as we heard in the snippet earlier, any witness that the state did not call during the proceedings will now be made available to the defense to also call in an attempt to show that their clients are in fact innocent of these charges. So, it's difficult to say now yet whether the case has been proven against him beyond a reasonable doubt, because I do think that there is evidence that's been placed on the record that needs to be answered to.
And for the family,
do we think we have the right people there? And I said yes. I haven't changed my mind. That's still my view on both questions, that we have the correct people before court, and I would have wanted other people to be charged as well.
Criselda Lewis, SABC News in Johannesburg.